privilege for me to welcome everyone to the Global Environmental Law Centre's first public lecture, and we hope to have many events like this in the future. My name is Dr. Angela van der Berg. I am a senior lecturer at the Faculty of Law in the Department of Public Law and Jurisprudence at the University of the Western Cape, and I'm also the current acting director of the centre. And today we have invited, or we have the privilege of having Professor Werner Scholtz speak to us about some of his recent research on wildlife law and ethical and humane use in the conservation of Convention of Biological Diversity. But before I ask Professor Scholtz to join us, I will just give you some background on his professional CV. So Professor Scholtz received his PhD in Leiden University in 2001. He is the head of the School of Environmental Law, in Southampton University. He's also an extraordinary professor at the Global Environmental Law Centre here at UWC. His current research focuses on the consequences of increasing importance for animal welfare and in the context of international wildlife law. He is an Alexander von Humboldt scholar, he is a rated NRF researcher, and he is really published widely in the field of international wildlife law. So without further ado, I'm going to give the floor to Professor Scholtz. Thank you.
Thank you, Angela. Well, my recent publications are about wildlife laws. I think it's according to is not totally incorrect. Thank you for the opportunity to present some of my most recent work in front of previous colleagues and people who are also watching from home. My title is Lions Are Not Tasters, and I'd like to explain that further. It deals with the issue of compassion and ethical and humane use. Next slide, please. So in the 40 minutes, I don't know if you'll be able to see that, it's not very visible. In the next 40 minutes, I would just like to refer to a few interesting things. My presentation focuses on the issue of so-called sustainable use, which is frequently in international wildlife law equated with consumptive use. So it's an instrumental approach to utilization of wildlife, both lethal and non-lethal use as such. And there are numerous examples of these issues that we deal with, also in South Africa, pertaining, for instance, to captive breeding of the African lions and tigers and so forth, for instance, derivatives of lion bone or lion bone itself, can hunting, trophy hunting, trapping, whaling, hunting of whales. Those are all aspects and facets of this interesting debate in relation to sustainable use. And in South Africa, the issue was very much at the forefront of the recent debate that resulted in the adoption of the so-called high-level panel report on the management, breeding, hunting, trade and handling of leopard, lion and rhinos. And it was very much an issue about the question whether what is sustainable use? Is it consumptive use in section 24 of our constitution? This high-level panel report is supposed to feed into a policy on biodiversity conservation and sustainable use, and essentially also adopt a welfare approach to wildlife. And we've had contentious debates concerning this issue, also an engagement with the Minister concerning the question, and really central was this issue about sustainable use and consumptive use. And in this presentation, in relation to the background that I've just given, my main focus is, or relates to, the legal issues of sustainable use in international environmental law. Next slide, please. So, as a way of introduction, are you able to see anything? Not really. Is it possible to just change, maybe just make it a bit more brighter on the screen? it's not really possible. And let's just like to see this. COP7, the COP7 decision in relation to sustainable use is sort of the point of departure for this discussion that we will have. The Addis Ababa principles and guidelines for sustainable use was annexed in this decision, in the COP7 decision on sustainable use. And it's very interesting to refer to two aspects of that decision. The one is the operational guidelines to Principle 11 of the Annex, which requires the promotion of a more efficient, ethical, and humane use of components of biodiversity. So ethical and humane use, and I'll explain why that is quite peculiar. And then Principle 10, which states that international and national policies should take into account intrinsic values of biological diversity. Those are the two most important aspects I would like to focus on. Why do we use the COP7 or the decision on sustainable use as the point of departure for this discussion? It is the foremost decision on sustainable use. That's clear from the preamble. If you read the preamble, it refers to the fact that the decision is a tool to achieve the objectives of sustainable use and conservation in biological diversity. But in addition to that, the decision itself makes it very clear that it creates the principles creates an advisory framework, and the guidelines provide functional advice on the implementation of the principles. And then one could argue that this annex that I've referred to essentially constitutes a normative interpretation of sustainable use in the CVD itself, in the instrument itself. The question here is, so we've established the fact that it's a very important decision. And the question is then, what is ethical and humane use? Because the CVD, the convention, has no reference whatsoever to this concept of ethical and humane use. Nothing. And the second question is, in conjunction with the reference to intrinsic values, what would be the implications once we've established the meaning and understanding of that concept for sustainable use, the concept of sustainable use, which is one of the primary objectives of the CVD in terms of Article 2. And that is going to be my primary focus in terms of this discussion. And I will canvass sort of the landscape via reference to two interesting South African judgments and explain why I'm going to deviate to national law. That's the first aspect. And then second of all, we need to take cognizance of the relationship between sustainable use, sustainable development, and intrinsic values in the context of the CVD. And lastly, one of the last components, the issue of humane treatment as an expression of welfare in terms of this intrinsic concept, in order to then determine what the implications of ethical and humane treatment are for sustainable use in the CVD. Next slide, please. The first decision or judgment that I just briefly want to refer to is the NSPCA judgment of 2016. I will not deal with the facts because I don't have time. I just noticed that. So I'll just briefly refer to the most pertinent issues and profound aspects of this case. So this case actually dealt with the ritual slaughter of camels. There was an issue about private prosecution, which I'll not deal with. I just lost the slides. So I just want to simply switch on the slides again. While they're doing it, maybe I should just try to actually analyse the case further. The NSPCA case so dealt with the ritual slaughter of camels. So it did not really deal with biodiversity. But the issue here, or the court clearly related to the issue of biodiversity and actually went further than the mere issue of the slaughter or the ritual slaughter of cattle, and the issue of private prosecution. And there are a few profound aspects of the case I would like to mention. Very interesting in this case is the fact that the judgment makes it very clear that there's not a dichotomy between animal welfare and conservation. Those issues are interlinked. And the issue of respect for other entities, in addition to human beings, is a very important aspect of our law. And the court actually distilled this from section 24 in the Constitution itself. So it's a very interesting progression in this regard, where in some really profound aspects, because in international environmental, international wildlife law, the discourse and debate has been about, to an extent, the distinction between conservation, and this is frequently the debate when we talk about, for instance, captive breeding. The question is whether it results in conservation. And biodiversity legislation does not deal with welfare aspects. Good. I'll just continue. Maybe if I can smooth over so I can see my own slides. I'll just move over and then I'll just focus and try to focus on my own slides. I don't think it will work. Excuse me just 1 second so that we resolve the technical issues. Yeah, thank you very much. So a very important case. Very profound aspects in terms of this case. And the case itself in the judgment referred to length on time. And I'd just like to, the verbatim quote, just quote it. Constitutional values dictate a more caring attitude towards fellow humans, animals, and the environment in general. It's a very interesting citation. And as I've mentioned, not only in relation to companion animals, but also in relation to biodiversity. This case is important due to the fact that it's a South African case, but it's important due to the fact that in terms of transjudicial communication, as proposed by Andrew Slaughter, there's a global dialogue amongst courts, national courts, international courts, and tribunals that deal with shared issues on the basis of the rule of law. So I think in terms of foreign law, this could be very interesting. And it already had an impact to an extent in terms of scholarly writings all over the world. But there's also a second component, and that is the fact that in terms of the general principles of international law, the statute of the ICJ, due to the fact that South Africa follows a stare decisis approach, it is possible that it may contribute to general principles of international law in terms of animal welfare. And Michael Bowman, and co-authors have actually made this argument previously in the authoritative Lister book of 2010, where they clearly argued for the creation of a general principle of international law. So I think in terms of the global perspective and the global implications of this case, it is quite profound. Next, please. So what the court has done is to indicate that the rationale for welfare is intrinsic values. I'll explain what it means in a short while. And the court referred to the so-called integrative approach in terms of our constitution. Remember, our constitution does not refer to welfare. It refers to conservation and sustainable use. There is no mention of welfare. But the court said that welfare is connected with our constitution in section 24, because it links the suffering of animals, the welfare component, to conservation, and it strengthens environmental protection efforts. So it's quite an interesting sort of perspective on these things. The second case, I just briefly going to refer to, deals with the setting of quotas of lion bones. I won't deal with the detail of the case. But it's also in the SPCA case with the Minister of Environmental Affairs and others, 2019 case. And in this case, the interesting aspect, I'll just just distill some of the most, or reflect on the most important aspects of the case. One issue is the case, as I said, dealt with the animal export quotas for trade in lion bones, derivatives, and so forth. And in terms of Section 60 of the National Environmental Management Biodiversity Act, there's a provision that places an obligation on the minister to consult with the scientific authority, and the scientific authority, on the basis of science, provides the minister with advice in order to make a so-called non-detriment finding. The interesting thing here was that the applicants, the NSPCA here, contended that in the process of consultation, animal welfare was not taken into account, was not considered. The response of the respondents obviously was the fact that Section 60 deals with scientific information, the scientific nature, no reference to welfare whatsoever. And there's no regulatory welfare mandate for the Department of Environmental Affairs to regulate welfare. The interesting thing here was, so the minister's argument also, in addition to this, was that she said that, she made it clear that in determining the annual export quotas, she must find a balance between social, economic, and environmental factors. And she suggested essentially, I would like to read, is that applicant under the guise of environmental concerns overemphasize the welfare factor to the exclusion of social and economic factors. So essentially she said, we're dealing here with sustainable development, so economic development, welfare is not part of that paradigm, it's not part of that matrix. So this is section 24. So she to an extent ignored, I think, the case that was analysed in 2016. Next slide, please. The court rejected the arguments of the respondents, including the minister, and point the welfare issue of, because it essentially dealt with lions in captivity in terms of section 24. So clearly linked section 24 to welfare. And the court said the following: their suffering, the conditions under which they are kept, and the like remain a matter of public concern, and are inextricably linked to how we instill respect for animals and the environment, of which lions and in captivity are an integral part. So section 24 is the point of departure when we deal with welfare. And they cited the 2016 case and affirmed the relevance of intrinsic value. And lastly, the court decided that there was a contravention of section 24 due to the fact that the welfare of lions in captivity was ignored in this process. Next slide, please. If we briefly reflect on the two decisions in order to move, or to distill lessons from this, for the debate that we currently have in relation to sustainable use in the convention, which is an international instrument, I'd just like to reflect on a few issues. There are some interesting lessons that we can learn for the reinterpretation of sustainable development and sustainable use in terms of biological diversity. Because in the lion bones case that I just analysed, the court clearly rejected the dichotomy between science and ethics, because that's also sort of a typical exemplary representation of the debate. Animal welfare versus conservation. Welfare relates to ethics, conservation relates to science. And that dichotomy was essentially was dealt a blow in this case. There's a reconciliation of welfare and conservation as two important components. You can't, and that ignorance of welfare was clearly refuted. So what are the consequences of sustainable development and sustainable use? If we take cognizance of the lion bones case, it is quite clear that there's a realignment of the factors of sustainable development, or the elements, which are the environmental, the economical, and the ecological. And clearly what done is that there was an importation of the welfare component under the environmental component as part of sustainable development. So it's a bit of a reconfiguration. So animal welfare is part of the consideration of animal welfare of sustainable development and sustainable use. And there's a recognition of the importance of the intrinsic value of individual animals as a rationale for welfare. So a very important aspect, as well as an injection of non-anthropocentric ethics into sustainable development. Next slide, please. Now, quite clearly, as I've mentioned, the two cases that I've discussed are not merely of national relevance, but of global relevance, not merely due to the legal consequences or even the more informal consequence in terms of global dialogue, but also due to some lessons that we can distill from this for the international debate. And if we talk about international debate, and I'd like to refer to my initial question, what is ethical and humane use, and what are the implications for sustainable use in the CVU? Then it's quite clear that there needs to be a considerable reflection on intrinsic value and the role of the intrinsic value in relation to sustainable use and sustainable development. Article 1 of the Convention on Biological Diversity in the preamble refers to intrinsic values. It includes intrinsic value, and it reiterates the importance of Principle 10 that I've discussed. But there's an interesting interesting aspect here in Article 2, because Article 2 refers to an instrumental or anthropocentric approach to sustainable use, which states that the use of components of biological diversity in a way and at a rate that does not lead to the long-term decline of biological diversity, thereby maintaining its potential to meet the needs and aspirations of present and future generations. So it refers to inter- and intra-generational equity. That's the one component. So it's an anthropocentric focus. Sustainable use essentially operationalizes sustainable development. That is right. The problem is, however, with sustainable development is that it's ill-suited to balance these factors that I've mentioned: environment, economic. You can see that in the case. There was a focus on economical aspects. So it's difficult in the case of trade-offs between the environment, the economy, and so forth. And there's an overly economic focus, an instrumental focus, in terms of the values. So if we talk about, and I'll refer to intrinsic value, why is it important that we deal with intrinsic value? Because values are important because we protect what we value, essentially. That's why I've just discussed the issue that there's a very strong economic focus. You will cherish the economic aspects there. Sustainable use is, as such, if we discuss sustainable use or the environmental and environmental values, we have three values: intrinsic, inherent, and instrumental. Intrinsic has no external adjudicator. A person has value in itself, for himself or herself. It does not depend on a second or third party to determine his or her value. Instrumental value is obviously a utilitarian concept, whereas inherent value can be deducted from, for instance, religious values or so forth. But our focus is on intrinsic value in the preamble of the CVU. And wildlife presents an interesting and useful example to discuss this matter. Because what we see in terms of biodiversity law, there's a dominant anthropocentric focus on biodiversity law that essentially fails to encapsulate the non-economic values of wildlife. And that's why I've mentioned in my title, lions are not tasters. They're sentient beings. They're not computers, they're not mobile phones that you can just use. consume. So that consumptive paradigm does not work well here because we're dealing with sentient beings that can experience pain and suffering. But unfortunately, the biodiversity has a very strong focus on the instrumental approach. Biodiversity will focus on the prevention of extinction of species, and not as such on individual animals, on individual wildlife. And the conventionalist itself accepts this consumptive use of animal species if certain conditions are met. But the issue is, and the problem is also in terms of this paradigm, is that human beings are interwoven with animals and the environment. We're not separate entities. So that anthropocentric justification and overly instrumental approach does not adhere to ecological realism. So essentially the problem is that in terms of instrumental values, wild animals are resources, seen as resources, to serve the economy. Cat hunting, lion bones, rhino horn, and so forth and so forth. And there's a prioritization of economic interests to the exclusion of other values. Next slide, please. So there's a need to respond to this dominant anthropocentric and instrumental approach, and the dichotomy of humans as users, consumers, and animals as resources, wildlife, wild individual animals, in order to provide for a moral recognition and legal recognition of the needs and interests of other species, but specifically individual animals. So what we've seen in the South African case law that I've just discussed is a clear recognition of the moral worth of species via an affirmation of the intrinsic values as a rationale for that moral recognition. And there's quite clearly therefore a compelling need for the recognition of intrinsic values, and if you refer to the CVD, that's the international instrument that I'm currently discussing. But as I've mentioned, the CVD contains a reference to intrinsic value. But the problem here is that, and I would like to quote Foster and West in a recent Berg in a textbook, intrinsic value seems more ornamental than influential to the substantive law. And the intrinsic value of individual organisms has received little attention. So you have it in the preamble, but it's ornamental. It does not infuse the provisions of the CVD. Next slide, please. So what is needed is to give more weight to intrinsic value in the CVD. And Bowman, Davis, and Wedgwood made the following remark: any sound ethical policy should additionally have regard to the extent to which individual organisms are permitted to flourish in accordance with their biological nature. Next slide, please. This sound ethical framework that Bowman has referred to necessitates a normative wildlife welfare framework, which recognizes the moral concern of animals that I referred to. And the crucial, the crux of the matter is the most important expression of welfare is the humane treatment of animals, humane treatment of wildlife, of individual animals. That is a core aspect of the welfare approach, which means that it invokes compassion for other animals, individual animals. And on that basis, there's an expression of sympathy. So that's an important thing, to prevent unnecessary suffering and pain. And there are various examples in international wildlife law of the issue or the expression of humane treatment. Humane killing is at the forefront of the IWC, International Whaling Convention. CITES, for instance, contains various references to welfare in terms of transport, but also very soft law documents that clearly provides for an expression of humane treatment. Humane treatment is not opposed to use, it's about the mitigation of suffering. So it's not totally opposed to sustainable needs. So prima facie, it's compatible with sustainable needs. Next slide, please. So in terms of the if we read the CBD, there's no reference to ethical and humane treatment whatsoever, or ethical and humane use. There's a reference to intrinsic value. Sustainable use is defined in terms of current and future generations. Also no reference to any of these other aspects. So there's as I've mentioned, that need for the recognition of moral worth, and the need for a sound ethical policy that actually gives effect to the intrinsic value of animals. An intrinsic value has two facets, the genotype and the phenotype, good of its own and good of its kind. And there's an interplay between the two. So that's where you can't refute the relationship between, on the one hand, welfare and on the other hand, conservation. Because good of its own relates to issues such as the individual animal, nourishment, the environment. Good of its kind relates to species. But good of its own obviously has an impact on the good of its kind, the fact that extinction can occur. So there's a need to take cognizance of that interplay. And essentially, humane treatment requires an injection of non-anthropocentric values in the CBD itself. So what is my argument here? Of all the things that I've mentioned, I hope you're not asleep at this stage. So quite clearly what we need is, in order to understand ethical and humane use, as well as intrinsic value, in terms of the decision that I've referred to, we can see that ethical and humane is nowhere to be found in the CBD. There's a very different sort of approach that is taken. But I think on the basis of ethical and humane use reference in the CBD decision, as well as intrinsic value in that decision, but also in conjunction with the intrinsic value in the preamble, I think there is clearly a possibility to argue for, on the basis of that decision, for an evolutionary interpretation of sustainable use and sustainable development, which recognizes animal welfare. So a recognition by adjudicated bodies, both on the international and national fora, to recognize the importance of animal welfare and as such humane treatment in order to give effect to the rationale of intrinsic value, because of the interplay between the facets of intrinsic value. My argument is in line with, essentially, with the preamble, because the preamble is a motivation for a treaty, and intrinsic value is encapsulated in the preamble itself. And intrinsic value is also important in the preamble for the interpretation of the provisions in the CBD. So this strengthens my argument further. Lastly, I've referred to the fact that there's an argument that has been made, and I've also made this argument, that animal welfare essentially could be seen to converge towards the crystallization of a general principle of international law in terms of the statute of the ICJ. That strengthens the argument further for an evolutionary interpretation of sustainable use in the CBD. Next slide. So, essentially it means that, and I think I have to conclude now more or less, what are the implications of this? It's not that all forms of pain and suffering or predation as such should be counted. But the implication is that ethical and humane use departs from consumptive use. Wildlife should not be used to satisfy human needs without sufficient justification. And it imposes a reconfiguration of sustainable development, which includes animal welfare as part and parcel of the environmental component of sustainable use. And it also leads to a further infusing of sustainable development with non-anthropocentric values. And it as such strengthens the environmental pillar, I think. Next slide, please. Concluding remarks. So what I've done is to briefly indicate that there is a problem here in terms of our approach to wildlife. It has been recognized. It's the consumptive approach, which is frequently seen as something similar to sustainable use. But there is hope. There are certain glimmers of hope, and we can find those glimmers of hope in the COP7 decision, which provides us with a basis, in conjunction with the preamble, for an evolutionary interpretation of sustainable use, which could actually have interesting impacts on sustainable development itself. And South African case law provides us with interesting beacons in this regard, in this exercise. So, lastly, my concluding remark, yes. Is this a radical approach that I'm suggesting? This is something totally new. It is not as such. The General Assembly of the IUCN in 1990 mentioned the following: ethical, wise and sustainable use of some wildlife can provide an alternative or supplementary means of productive land use and can be consistent with and encouraging conservation, where such use is in accordance with the vision for the protection of wild animals from avoidable cruelty and suffering. So my proposal is not that radical, but it provides an integrative approach which recognizes intrinsic values of animals and responds to the one-dimensional extinction focus of biodiversity. So I'm pleading for a departure from consumptive use to compassionate use that reconfigures the moral work or the recognition of individual animals. And I think it provides fertile ground for further discussion and inquiry. And I've not been able to address all the issues in detail, but merely to flag some of the issues. And with that, I'd like to thank you for your time, and I have one last slide which you can show. Thank you very much for your time. I am open to answer any questions or take any suggestions as you see fit. Thank you.
Thank you, Professor Scholtz. I think I will start with a question and then give over to anyone else who might have a question. Thank you again for your insightful discussion of the CVD. The online audience can see the slides, so it's just us in the venue that have some technical difficulties. I was wondering what you think the role of recent domestic and international legal developments on rights of nature and that movement plays in strengthening or maybe even detracting from consumptive use.
So there are a few aspects to this issue. So if we talk about rights of nature, obviously I did not refer to it, it's in the publication itself where I referred to that. So that stems to an extent, it has a very long history. It stems from Christopher D. Stone, and it's materialized to a point now where we've seen various cases that actually affirm the rights of nature. I think it provides or it strengthens the case because it deals with non-anthropocentric values and ethics, and it provides for a strengthening of that approach, which I've actually suggested. So it also relates to respect for nature. Harmony with nature, the UN initiative is also another thing that one can mention. But there's an additional aspect to this, obviously. I've just spoken about the welfare issue. I've not dealt with the elephant in the room, the issue of rights of animals. There have been recent cases, and that's progressed now over the past years to a point now that it was a recent, I don't know if you've seen the Pablo Escobar cocaine hippos case. It was quite interesting where the rights of those hippos were recognized. So animal rights have been now recognized in various foreign jurisdictions. Now what we see is a rights-like approach, which can be equated to an extent with some forms of welfare. So there's a very interesting progression. There are all these things that really have a very interesting influence on this debate. And I've just focused on a very small part of that. I'm currently working on a publication that deals with so-called wildlife rights, which is very controversial issue. It's a non-starter essentially. If you facilitate debate between environmentalists and animal rights experiments, it's not really an issue that they want to start. But so there are really some very interesting developments outside the past 5 years. There's been this trajectory towards the recognition of rights of nature, animal rights, even now wildlife rights.
Thank you. Are there any specific questions from people in the audience today?
Thank you so much. That was very interesting. And as a pet owner, I was always very scared that this will move towards me not being able to have dogs anymore. But my question is, and you might address that if you want to, but my real question is, the cases that you dealt with, the South African cases, are there similar cases in foreign jurisdictions, and did they come to the same conclusion, or did they decide something?
I can think of a number of cases that resonate with the two cases I referred to. The European Court has, for instance, had a very interesting case which I think resonates with this. This was a very specific, or these were two very specific cases, very progressive cases, 26 and 29. The interesting thing is obviously the fact that we have Section 24 environmental right, which is justified under the Constitution. And on the basis of that right, there's no reference in Section 24 to welfare. And well, in previous cases even, the predator breeders case, the decision was quite clear that there was no legal mandate for the regulation of welfare in terms of biodiversity legislation. So this is a sort of a paradigm shift, a radical departure from sort of a previous approach. So that's why I think these cases are really profound. But there are certain cases that resonate, I think the Gearing case is one case like that, I think, where quite clearly I did not discuss this because this is part of a new publication, the importance of environmental rights, that you can use environmental rights essentially, to promote a welfare approach. And that distinction, that stark distinction between rights and welfare, is also superficial to an extent, because you can have a very strong form of welfare protection, which is merely rights, whereas you can have symbolic rights that do not provide the same. And I'm not saying it's always the case, and I know what the arguments will be for animal rights experiments. I'm fully aware of that. But quite clearly there's a certain progression in this instance. That's why I refer to the fact that I think that the two cases could play an important role in that global dialogue. And we Slaughter, this is way back, actually, she published a few articles on transjudicial communication. I think maybe these could be good examples where other courts that face similar issues refer to these cases and cite these cases. And I don't think you should be concerned about the fact that your pet will be repossessed. I don't think that is the gist of this at all, because it also has to do with intrinsic values. And wildlife, the problem here is that wildlife need to flourish in accordance with their biological needs. And to keep lions in captivity contravenes exactly that. Or to use a factory farming model, transpose the factory farming model for wildlife. It contravenes exactly intrinsic values of animals. That's for me, the intrinsic value is the most important component in this instance. I don't know if I answered the question.
Are there any other questions from anyone else?
There's one.
Thanks. My question is not very clearly formulated, but so if I understand correctly the argument, that I agree with it, that this progression and so on. But the whole idea of intrinsic value, as I understand it, is also kind of a Kantian argument of Immanuel Kant about human beings having this inherent dignity. and for that reason they also have rights. And so philosophically, I've heard some people argue that you can't really now say that animals have also inherent dignity and therefore they also have rights, because it's in a sense, you know, that has always been the argument why you can do with animals whatever they want, and now you're giving them rights. So isn't that, shouldn't one look for a different kind of argument, perhaps a different kind of vocabulary to capture what is called the rights of animals or the intrinsic value?
That is a fantastic question. It's something I'm currently working on. So first of all, the argument now is that dignity should not be reserved only for human beings. It's arbitrary to an extent. It does not accord with scientific knowledge, and there's no real reasonable justification for the reservation of human dignity only for human beings. So that would be one argument. So to argue for a more inclusive form of human dignity, which is more comprehensive, and then to state that dignity is not, it's something that can, you know, that other entities can also have. And on the basis of dignity, obviously, you can then make certain, draw certain conclusions. My argument is, I don't deal with rights as such. So I dealt with something to the extent that differs. But my argument, and this is a publication that I'm currently trying to complete, is that on the basis of intrinsic value, which not, I'll just try to summarize, but intrinsic value is the, in terms of welfare, intrinsic value is the rationale for the recognition of the moral worth. Recognition of moral worth means that there needs to be recognition of welfare. If you take that argument further, on that basis you can then create, of course, normative wildlife welfare framework. You then incorporate ethical and humane use, which is not really consumptive use. But if you take that further to its logical conclusion, you can also state that if we follow that further, that in terms of, or that on the basis of intrinsic value, one could then, as a subsequent argument, state that wildlife, what individual animals have intrinsic value, they require moral worth, so how should that be accorded? Can we then argue for a more expansive form of dignity? On the basis of that expansive form of dignity, should that then be accorded rights, whatever that means? And we also, of course, need to have some clarity about the word rights. On the basis, for instance, of the inquest theory, it could be quite interesting, because intrinsic value is also recognized in terms of the inquest theory, which states that, or in this instance, the application would state that while animals have certain interest in their own well-being, it differs from a rock or a mountain. And that's the rights of nature. But they've, in their own well-being, interest in their sentience. And on that basis of the interest theory, they have intrinsic interests. You can then make an argument on that basis for rights, for the allocation of rights. And you can go further and state that dignity, or you can accord even forms of dignity. And I'm thinking of one or two cases where they've already done that animals also have dignity, that it's not reserved for the domain of human beings, Homo sapiens. And then you can, on that basis, you can generate rights like protection for animals. My argument is that dignity would provide content and substance through the rights given on the basis of intrinsic interests. So obviously, and this is something that one can also debate, the whale, for instance, clearly has different interests and intellectual capacity and so forth, and one can respond to that intrinsic values in a certain manner. And that's why the argument that I've also made is that there should be, and others, there should be a prohibition on whale hunting on the basis of welfare provisions. I know that it's a very difficult issue because it actually, I mean, personally, is that because it's sort of, to an extent, it challenges us to consider these issues that we've always thought about, dignity, human dignity, or legal personhood is another interesting example. And legal person only reserved for human beings. So all these things are being challenged currently, and that makes it quite interesting. But you have a very valuable point.
Thank you. We have a final question from the audience.
Thank you for the most interesting presentation and talk. And this speaks to the raised by Scholtz. I mean, if one looks at the history of humanity, where slaves were once regarded as less than human beings, and if one refers to the writings of St. Francis of Assisi, who said humans were the overseers of all living things, of all sentient beings, of all sentient creatures, which you raised in your discussion. So it begs the question, decades from now, do we still adopt a very parsimonious interpretation of dignity? Is it reserved only for human beings with intrinsic self-worth, or do we attribute that also to sentient beings? I know Beaches has written various articles in this regard, and various countries recognize or for maternity leave that you can take leave for your pet. So I think it's important that we have to recognize that this is an ongoing evolutionary concept that we're dealing with. It's not necessarily static, and it's important that there's not a one-dimensional approach to the concept of dignity, the intrinsic worth of an animal. Not to the exclusion, and sorry, just one last point, as far as I'm aware, correct me if I'm wrong, that the Indian High Court, or the Supreme Court, has recognized rivers as having rights and obligations. I mean, that's an inanimate object. So they feel very in respect of animals. Thank you.
This one is a very valuable point. So dignity is not static, and I think everything it's important to continue this trajectory. And the Indian courts have just, but Indian courts have referred to, in recent cases, to dignity linked to animals as well. So there have been various court cases where they've been very progressive in accepting the dignity. So it's not something that, it's not a bit of academic interest, it's already taken place in foreign jurisdictions. And the case that you referred to in New Zealand is also an example. There was also a case in New Zealand where they referred to the rights of the river. So this is not, it has already taken place to an extent, and we can see sort of a rapid development in response to these measures. Yes?
I just follow up. We talk about rights, and often we think that rights are inborn or inherent, but rights come as a result of struggles. And that's why we have this evolution of rights. So if you take that line of argument, then at some point we can get to that point when we talk about rights for animals. So it also depends how we look at rights, I think, how we get to rights. Thank you.
It's about vulnerability. So because it's the progression of slavery, racial discrimination, all those struggles that resulted in the allocation of rights. So it's about the vulnerability of certain people, in this instance, vulnerability of animals that necessitate an allocation of rights.
Thank you. I have a last question just to bring it back to the South African context. So we've alluded to progressive courts in India, and I think the Lion Bones case is also an example of our judiciary being progressive. And they did touch on Section 24 of the Constitution, but I'm wondering what your idea is on redeveloping or editing the Constitution if necessary, considering that it is really focused on human interest in the environment and not the other way around. So if we didn't have a progressive judiciary, is Section 24 enough?
Well, I think now there's a purposive approach that they've taken. So they've actually essentially read welfare into the Section 24 in terms of stable use and environment. So it already exists. And it was on that basis in 2016 that actually was led to a number of developments, and that led to the high-level panel report where the minister clearly indicated they will prohibit captivity of lions. And it's purely based on the progressive interpretation of the courts of 2016 and 2019, which made it very clear that animal welfare is now part and parcel as a consideration of biodiversity law, and the authority for this is to be found in Section 24, where there is no reference whatsoever to animal welfare, but it exists in terms of the issue of respect, in terms of Section 24, and the integrative approach. There's an integration of that component in sustainable use and sustainable development. So I don't think that there's a need, well, it would be, I think, to an extent, a purely academic also debate, but I don't think there's a need to revise or redraft the Constitution as it stands. I think on the basis of stare decisis, it is quite clear that, and you can see it in current developments also, the recognition thereof, although with some reluctance in certain, but there's a clear recognition that animal welfare is now part of our law. And I mean, the Lion case was decided on the basis of Section 24. They didn't really refer to it. There was a clear contravention of Section 24. And so it's very clear in my mind. And I think it can be used further for strategic litigation in the future.
Thank you. I agree, and I really think that is a positive note to end your discussion on, to say that we have a strong environmental right, and we don't only have to use it to advocate for human interest in the environment, but maybe we will start to see more court cases akin to that in New Zealand and India and those jurisdictions. Thank you very much. I really appreciate you being here today, and I think we can everyone give Professor Scholtz a hand of applause.
Thank you for your time. Thank you.
For everyone who is tuning in online at the moment, we will make the presentation available, and the slides were available on the video, but we will share that on the webpage. And if you have any questions, you can contact the Global Environmental Law Centre, and we will also make Professor Scholtz's details available for anyone who wishes to speak to him about questions they may have. Thank you.